Let's begin. Thanks for coming on a Sunday morning. It's not easy, but I think we have to do this. So today, before we start talking about the main topic, which is the law applicable to the arbitration agreement, we have about 5 cases to cover under that. There was a case left off from last class on the principle of competence. So let's first cover that case and then move on to the other cases. This is actually a very good case for us to be transitioning from the question of competence to the question of the applicable law. And in a way, the question of competence has the question of the applicable law within it, even in this case, right? They had to look for a rule of decision before they decided whether the arbitration agreement was valid or not. So in what context did the question of validity arise in the Dalla case? What was the most serious problem that the court was confronted, the UK Supreme Court, and how did it get there? How did it get to the UK Supreme Court? Did you follow the procedural history and why we're dealing with a court decision of the highest court in the United Kingdom? I think back in the 2000s, I don't know exactly whether it was 2000 and, was it 2004 or 5? When they actually established the Supreme Court in the United Kingdom. The United Kingdom obviously did not have a Supreme Court until very recently. The House of Lords was the judiciary. They had judicial authority, and some of the cases that we've been reading was from the House of Lords. You know how they write their opinions separately, yours so and so, yours and so and so. They set up their Supreme Court very recently. Now this is 2010. So it's the UK Supreme Court decision. That's the highest judicial authority now in the United Kingdom. So how did this case get into or before the UK Supreme Court?
Go to the UK Supreme Court to enforce arbitration award.
Yes. So the way it got before the UK Supreme Court is through an action to enforce an award that was made in favor of Dalla, the company. And it was awarded, if I'm not mistaken, about 20 million US dollars. So they had a 20 million award in their favor. They wanted to get that thing enforced. And what was the problem? What did the state of fact stance, what was the state of fact stance objection to the enforceability of the 20 million US dollars award in favor of its adversary company in this case?
It's not a party.
That was, so their objection was, we weren't even a party to the arbitration agreement, right? So that became a question of what?
Enforceability and validity of the agreement between the two parties.
Exactly. So the question became whether or not the agreement bound the two parties. In other words, whether or not the basis of jurisdiction of the tribunal was valid. So in other words, whether a third party to that agreement was bound by the agreement, whether Pakistan as a state was bound by the agreement that was signed between Dalla and the trust. So the Pakistani government set up a trust, right? So a trust is actually a legal entity. It has the power to enter into a contract and to sue and be sued. So the Pakistani government has set up a trust. What happened to the trust? It lapsed. It lapsed. The trust lapsed, so therefore it no longer existed. If the trust didn't exist, these guys had to find someone to sue, right? They had to sustain damages. So what was the most important evidence that they presented to show that the state of Pakistan was actually a party to the agreement? What is it that what was the basis of their argument factually? They say, oh, the state of Pakistan was a party to this agreement because
the government is a guarantor of this trust.
So they signed as the guarantor. Okay, that doesn't make them a party.
They say that it's alter ego. So actually the trust is owned by the government.
Okay. Before we get to that point, when in conducting the analysis, the UK Supreme Court, before they even got into the facts, they had to identify the applicable law, right? They had to identify what law governs this particular arbitration agreement. We're not talking about the trust, we're not talking about the construction agreement. So they said, let's first find out what law governs. French law. Why?
It's a place that the arbitration happened.
French law because the arbitration was cited in France, or seated in France. So the seat of the arbitration being France, they had to look at French law, and on the basis of French law, whether or not the agreement bound the third party, Pakistan. And how did they get to French law? How did they arrive at that conclusion? Did they have another law that they applied to get to the applicable law? What led them to France? What law says the seat of the arbitral tribunal must be the law that governs the arbitration? It's the New York Convention, exactly. If you look at Article 5.1a, the validity of the arbitration agreement must be determined on the basis of the law in which, the country in which the award was made, or under the laws of which. So we'll talk about the difference between the two. But for now, it's the New York Convention that actually refers the court to France. Because the tribunal was seated in France, they applied French contract law to determine whether an agreement bound a third party. That is a contract interpretation question, right? Whether a third party is bound by a contract, you need a set of rules to determine, to be able to determine whether or not that is true. Right? So the most serious question was whether or not the state of Pakistan was bound by an agreement that was signed between the company Data and the trust that the state set up for this particular purpose. Now, finding the law is not the end of the inquiry. Of course, the law had to be applied to the facts, and then, of course, a conclusion drawn from the law. So what did the facts show in this case? And what were the arguments on each side? So obviously the government was arguing that, oh, we're not bound. But for Dala, what were the pieces of evidence that they presented to show that indeed Pakistan was a party to this agreement? The first thing was mentioned earlier, that they were guarantors. They signed as a guarantor. I don't know which way that cuts actually. Does it make it more like a party or a guarantor, a third party guarantor? You know how states usually, when state entities borrow money, states provide sovereign guarantee, right? In case they fail to pay, sue. I don't know why they did not sue the state of Pakistan as a guarantor. Instead, they sued them directly for breach of contract. I'm sure there are some complications in the contract or instruments that did not permit them to proceed against a third party. In fact, the possibility is such that I think the guarantee instrument may not contain an arbitration agreement. Say, the guarantee instrument might actually just simply say court litigation in Pakistan. In which case, instead of proceeding against them under a guarantee instrument, they wanted to sue them before a tribunal for breach of contract. That might be, I don't know, the facts are not very clear. But instead of proceeding against them directly as a guarantor, they wanted to bring them in as third-party defendants. And to bring them in, you have to demonstrate that they were a party to that particular arbitration agreement. Applying French law, the court undertook a very lengthy analysis of whether or not a third party under French law is bound by an arbitration agreement that it didn't sign. One of those theories was alter ego. So that inquiry comes from French law. Under French law, if you are the alter ego of a particular juridical entity, you may be bound by the arbitration agreement even if you have not signed it. So what's an alter ego? So if you have this company A here, and then company B, C, D, this is the main company. This is deemed to be the alter ego of this. If what happens?
He does the same business and
same stuff.
Yeah, all those kinds of things, right? It's basically A is using B not as a legitimate subsidiary or a legitimate company, but to shield itself from liability and engage in some kind of inappropriate illegal behavior. So there is this very close link with them. The only purpose B exists is to actually shield A from liability, not in a legitimate way, but to conduct fraud, things like that. So you're just basically using a separate corporate entity for illegitimate purpose to shield yourself. So that question was whether the state of Pakistan set up the trust as its alter ego for no legitimate purpose other than just to engage in cover-up with fraud and things like that. That was one of the questions that the court had to look at applying French law, and they obviously did not find that to be true. It appeared that it was a legitimate trust set up for this particular purpose. They had no reason to believe that it was the alter ego. Another theory they applied was what?
Common intention to be bound.
Huh?
The parties have common intentions to be bound by.
Common intentions, yes. Whether or not the two had common intentions and whether in fact the Pakistani government had the intention to be bound by the arbitration agreement. So that apart from the corporate law analysis, that is finding the intention of the parties to see if the Pakistani government. But going back to the corporate structure, corporate law analysis, there is the alter ego. What was the next one?
Successor of the trust.
Successor in interest. What else?
Rights and obligations.
Yes. And what else? They talk about agency, third-party beneficiary, things like that. Those are the kinds of inquiries that you engage in if you apply corporate law principles to see if the state agency, the state entity, is actually is closely related with this one, so that you can bring the third party. We'll talk about third party beneficiaries, agency, and things like that. There's one particular class for that, as to how you bring in third party independence in these kinds of cases. But now, it's enough to just focus on how the New York Convention led to France, how the British court actually applied French law, and what are the facts that actually the company presented to show that the state of Pakistan is bound by the treaty, by the agreement, although it has not signed it. But there was one very essential piece of evidence that Dalla presented showing that the state of Pakistan was actually a party to the arbitration. The two, the trust and the company, are one and the same. Huh? Exactly. That was the most important piece of evidence. There was a letter written by this guy, the commissioner, the minister. He signed it, and what was the letterhead? Yeah, so, but he used his own, the Pakistani government letterhead in the letter, and he signed it. But he was writing on behalf of the trust. They said, oh, look, they're one and the same. But did he sign it in his capacity as the minister, or he signed it in a different capacity? What saved the day eventually for the Pakistani government? This letter was a very damning evidence against them. He was writing on behalf of the trust, and he used his own letterhead from the ministry, and he is the minister, and he signed it. So why wasn't enough? Why was this piece of evidence not enough to show that the Pakistani government was a party to this agreement? That is the key point. In what capacity was he signing? On behalf of the trust, and what was his relationship with the trust? This minister. Huh? He is secretary of the trust. See? The court believed that this is a coincidence. He was not signing as the minister of the Pakistani government. He was signing it as the secretary of the trust. The other problem was, so why did he use the letterhead of the Pakistani government? If he used a letterhead that says State of Pakistan, says nothing about the trust, what was the excuse? Exactly. The trust did not have, they didn't actually print their own letterhead. So he just used stationery available in his room, in his office. So he signed it. So when he signed it on behalf of the trust, not on behalf of the state of Pakistan. How does all this kind of thing come up? You know, here in litigation, you're looking for evidence, right? They look at documents, they talk to witnesses, and then suddenly there's this amazing letter that says, oh, the minister himself signed it. And it's on behalf of the government. Look, I found this evidence. And then they go talk to him, maybe on cross-examination. I don't know if he testified, but he probably did. They show him this paper, and they say, Mr. So-and-so, minister, do you remember signing this letter? He says, yes, absolutely, I do remember. Exhibit 5A or something like that. Members of the tribunal, this is in exhibit such and such. And that's the end of cross-examination, right? You don't need to ask him any more questions. But his lawyers are going to get up to what? Rehabilitate the testimony. Mr. Minister, earlier you testified that you signed this letter on such and such date. Yes, and it actually shows that it's the letterhead of the government of Pakistan. Absolutely it is. Please tell the tribunal why you did not use the trust's letterhead. In common law litigation, you would actually object to that. That objection, it's a leading question. You have to lay the foundation, things like that. In any case, some such question would be asked. And then he says, oh, the reason why I didn't use the trust's letterhead is because we never printed a letterhead for the trust. So it was just a matter of convenience. So were you signing this in your capacity as the Minister of the Government of Pakistan? No, not at all. I was actually signing this on behalf of the trust because I was the secretary of the trust. No further questions. Please sit down. That is probably what happened in that courtroom. When this came out, and the UK court was actually duly impressed by that. And they said, yeah, this guy was signing it on behalf of the trust. After all, he was the secretary, so we confused it. His capacity as the minister, his capacity as the secretary. The fact that he was actually also the secretary of the trust was actually an extremely, extremely important fact for the Pakistan. Now, let's go back to the main question in this case. Remember, we're talking about the principle of competence. How does this relate to the principle of competence? This is not about choice of law, although it has some choice of law implications.
The issue is whether the court, UK court, should follow the award of tribunal because the tribunal has found that it has competence to deal with the jurisdiction issue.
Yes. So the underlying question was the validity of the arbitration agreement. Right? The validity of the arbitration agreement is the same question as the jurisdiction of the arbitral tribunal. Because if the arbitration agreement is invalid, what it means is that the tribunal lacks jurisdiction to exist. So this was reviewed at the award enforcement stage. At the award enforcement stage, the New York Convention permits the enforcing court to look at the validity of the arbitration agreement again before it decides to enforce or not to enforce. And the New York Convention says that the enforcing court must determine the validity of the arbitration agreement and hence the jurisdiction of the tribunal on the basis of the law of the place where the award was made. That's how you have all these complications. They are before a UK court applying French law principles under the New York Convention and trying to determine whether a third party is bound by an arbitration contract, which is basically the same question as whether or not the arbitration contract is valid as between the third party and the company, the claimant. And that's how they got engaged in the application of French law, corporate law principles about alter ego agency, third party beneficiary, things like that. And also look at the specific facts of the case to see if the two parties had common intentions to be bound. Looked at various evidence and finally determined that the state of Pakistan was indeed now bound. It was a guarantor, third party guarantor. There is a reason why they set up the trust. The very reason that they actually set up the trust is to insulate themselves from liability legitimately, not in an alter ego fashion. When you set up a corporate entity, legitimately, that's what you do, right? You insulate yourself from liability. There is a way to do it legitimately. There is a way to do it illegitimately through an alter ego to engage in fraud, to do things that are not appropriate. So that is what the court has found in this case, that the Pakistani government was not a party to the arbitration agreement. So if the Pakistani government was not a part of the arbitration agreement, the arbitration tribunal lacked jurisdiction in the first place. If you make an award without having the jurisdiction, your award may not be enforced. Okay? All right. Now let's move on to the law applicable to the arbitration agreement. Go to page 287. And tell me the four possibilities for the selection of the applicable law. We're talking about the law that applies to the arbitration agreement. What are the four possibilities?
The first one is the law expressly or impliedly chosen by parties to govern the arbitration agreement.
Exactly. So the first one is chosen by parties. Second,
the law of arbitration
seat. Third,
the law governing the underlying contract.
law of underlying contract. Fourth,
Fraud. The law from where judicial involvement of the government is sought.
award enforcement. So these are the four possibilities. Right? So here in the UK court, which one did they select? Which one did they select in the Dala case? Seat. They did. This is what they selected. The seat of the arbitration tribunal. Because this was the UK court, right? It didn't apply its own court, its own law. That possibility existed. The reason why they did not apply their own law is because the reason why the UK court did not apply its own law under number 4 is because, what's the reason? That was the award state, right? Why didn't they apply their own law?
New York Convention.
Exactly. New York Convention, Article 518 says the law of the place where the award is made. So they were just simply following the New York Convention. The seat of the arbitration tribunal. So then, when might, under the New York Convention, do not consider any other variables. Under the New York Convention, when might, number 4, be applicable? The law of the place where the award is being enforced.
If the award is enforced in the same place.
Exactly. It is if state 2 and state 4 are the same. Right? It's a little bit of mathematics. If the place of the award is the same as the place where enforcement is being sought, then you apply the law of the seat, which is exactly the same as the law of the award state, or the place where the award is being enforced. There might be other instances, but in many cases, it's when the two are the same. Okay. Those possibilities, let's explore these cases and see which possibility each one of these cases has selected. Now, this is a Tokyo High Court 1994 case. You have a New York party and a party from Tokyo. In their arbitration agreement, what did they set forth? What did they agree? What are the details of the arbitration agreement?
The agreement contains a clause referring all disputes to ICC arbitration and to be held either in New York at the request of GEC or Tokyo or in Tokyo. So they sit the ICC as an arbitral tribunal, and the law is either New York law or Japanese law.
And who has the discretion, the authority, the option to select which one applied?
If the party who reject arbitration. I mean, the opposite party who enforce the arbitration.
Exactly. So the opposite party, right? So this is what they did. It's an interesting one. There is Japan, New York. There is the Japanese party, and there is the New York party. If the New York party wanted to initiate an arbitral proceeding against the Japanese party, they need to go to Japan, and the vice versa. Make sense? Yeah, perfect. In civil procedure, if you want to sue someone, the easiest thing to do is to actually go wherever they are and sue them. Right? Then you know the court would have jurisdiction, at least personal jurisdiction over that person. You can't sue someone from Shanghai here and expect them to show up, unless of course they have assets that do business, contact, whatever the jurisdiction rules are. So that's what they agreed in this case, right? But that's not what happened, right? Who did what to upset this balance? In disregard of apparently, in disregard of all this arrangement, the Japanese party sued in its own court. Not only that, they actually sued someone that is not bound by the arbitration agreement. That's their excuse, right? They went to court and they sued this guy. Kaplan, what was his name? Rawlings. They sued Rawlings. He is a resident of New York. They accused him of engaging in fraudulent behavior. They sued him in Japan. So the Japanese High Court was confronted with the question of whether or not this guy, number one, was bound by the arbitration agreement. If so, where should the arbitration take place? And most importantly, to determine these questions, what law would they apply? Ordinarily, before you initiate a legal action in any court. The presumption in legal proceedings is that the court would apply its own rules, right? If you're in China, Chinese law applies. Chinese law on contracts applies. Unless someone else comes and tells you why you shouldn't apply your own law and instead apply some other country's laws. Renovi is the concept, right? It's possible that courts of law could actually apply laws from other countries. It happens all the time. But it requires justification. The presumption is that you apply your own law, unless someone demonstrates that there is a reason for you to be applying another country's law. In this case, they said Japanese law does not govern this particular dispute, this particular question. What was the question that needed to be determined? Huh? Yeah, that's true. But the main question for the court, the Japanese High Court in this case, was, so when this guy Rawlings appeared before the Japanese court, what do you think he said to them?
The arbitration clause is not one.
Rawlings? The New Yorker?
No, maybe I'll come to arbitration.
Yeah, exactly. So when they are sued in Japan, they obviously have no interest in defending a lawsuit in Japan. He probably did certain things that, I don't know what, but he was accused of some fraudulent behavior. So in any case, he sends his lawyers, and he pleads before the Japanese court, says that, Your Honor, you don't have jurisdiction because there is a valid arbitration agreement, and the arbitration agreement says that if they want to proceed against me, they have to come to the court. That's what I told him. Huh. And then, before they actually determined that question, they had to identify what?
Which law?
Exactly. The applicable law. And when a court is asked a question, the first thing they'd be looking for is to find what law should be applied to determine this question. Without law, court cannot operate. It's the fuel that runs them. So what was the law that they applied in this case? Why?
Because although the parties choose, there are two places for potential arbitration, but the process there is the presumption that the nature of the arbitration agreement to provide for giving procedures in a given place. So this litigation should be in New York court. So they apply New York law to the arbitration.
Okay, now let's go back to this list. Did the parties select the applicable law? By that I mean the law that applies to the arbitration agreement.
No.
They didn't. If they had, there would be no problem. Did the parties select seat of the arbitration? They did, right? But did they say that the law on the seat applies? They did not say that. So number one does not help us. Number two does not help us. Is there any reason why we think the law of the underlying contract should apply? We don't know. There's no analysis to that effect in this case. Is there a reason why we should worry about award? No, we're not there yet. There's no award to enforce. This is the very beginning of the proceedings, the process. So, how did the Japanese court arrive at, yes, the seat of the arbitral tribunal, the law of the seat shall apply? Did they rely on the New York Convention like the UK court here? They don't seem to. They relied on what?
Parties parties' autonomy.
Exactly. They relied on the parties' agreement. So they extrapolated, they assumed, they presumed, that's why I say presumption here, by selecting New York as the seat of the arbitral tribunal, we assume that the parties must have intended New York law to govern the arbitration. That is the analysis, in truth. We assume, we presume, that the parties must have intended New York law to govern the validity of the arbitration agreement. Why? Because they selected New York for this particular case. Would the result have been different if they had actually applied Japanese law? It would have been. Otherwise, you don't have a dispute. Right? If there are two competing laws, and both laws say the exact same thing, people are not crazy, they don't argue about that. It would make no difference. In this case, the applicable law was outcome determinative. It would have pointed to two different directions. And the application of New York law, did it save or kill the arbitration agreement? It saved it. Exactly. And how did they interpret it, and how did they find it? They say New York law is very broad, right? Must be interpreted that way to give effect to. The difficulty in this case about the validity of the arbitration agreement to proceed against this guy Rawlings was what? Just like the Dala case, just like the Pakistani government, this guy was third party, right? He didn't sign it. He didn't say he was an agent. And they believed that he was the mischievous one. They wanted to proceed against him. That's why they sued him in Tokyo. When they were sent back to New York, they also wanted to proceed against him in arbitral proceedings. This guy didn't sign it. But according to the Tokyo court, New York law is broad enough to bring him in, although he has not signed it. He's so closely affiliated with the process, he was the one who masterminded everything. He is practically bound by this. So basically, this case selects the seat of the arbitral tribunal to provide the law of decision as a matter of presumption. By selecting the seat, the parties are presumed to have selected the law of the seat. That's the conclusion. Not because of the New York Convention, because the New York Convention says that only as it relates to enforcement of the award. See, under Article 2.3, remember this is very important. Under Article 2.3 of the New York Convention, we don't have a choice of law rule. What we have in the state is what? What do we have from our last discussion? Under Article 2.3 is the provision that talks about the enforceability of the arbitration agreement. It's the provision that I told you they inserted last minute. So under Article 2.3, we do not have a choice of law. What we have is what? Huh? Huh?
The grounds and the way to decide.
Exactly. So the substantive grounds, that's what we have. They listed substantive rules, null and void, not very capable of enforcement. So instead of saying you have to determine the validity of the arbitration agreement using somebody's laws, They actually set forth the law specifically in the convention. So 2.3 contains a rule of decision. Article 5.1a contains a choice of law. It tells you what law to apply to determine validity. So that is the difference between the two. So when you are talking about the enforcement of the award, you are talking about a choice of law rule under this provision. But the inquiry, interestingly, is exactly the same, right? First, you look at the validity of the arbitration agreement to enforce the arbitration agreement. Second, you look at the validity of the arbitration agreement to enforce the award. They look at it twice. Why? Why? Technically, the court that is supposed to enforce the arbitration agreement may not be the same court that is asked to enforce the arbitration agreement. And indeed, under the New York Convention, that is what is contemplated. It's an award made in another contracting state. Otherwise, you don't need the New York Convention. If you have an award in State A, under State A laws, and you want to enforce it in State A, do you need the New York Convention? No. It's a domestic award, and you can just enforce it in State A. The only time you need the New York Convention is if you get an award in State A and you want to enforce it in State B. So State A, under Article 2.3, is asked to enforce the arbitration agreement. It enforces it. Arbitration takes place. The award is taken to State B, and of course State B is also asked to enforce. The guy who objected to jurisdiction here is going to do the exact same thing here, right? It's going to tell the courts of State B, the arbitration agreement is not valid. But the law that applies here may not necessarily be the same as the law that applies here for the exact same question of the validity of the arbitration agreement. Because here what they say is the law of the seats. And what they say here is null and void and operative incapable of being performed. It may not be State A's laws. See? It's interesting, right? State A is not allowed to apply its own laws for the determination of the validity of the arbitration agreement, but the State B must apply State A laws to determine the validity of the arbitration agreement. Ordinarily, in most cases, these laws are the same. Because null and void and applicable to be performed is interpreted more broadly, or no, restrictively to mean fraud, state, duress, and waiver, things like that. So the same line of inquiry may be conducted, but it's also possible that the list here is longer than the list here. The grounds of invalidity here that come from A might be actually more. Capacity might be included. Things like that. Undue influence, unconscionability, public power. Yes?
Under what conditions State A will not apply its own law?
Because if State A is a party to the New York Convention, under Article 2.3 of the New York Convention, the grounds of validity are limited. The null and void and operative. So they have provided a rule of decision to State A. So State A cannot say that, oh, beyond the New York Convention rule, I also have these other grounds of invalidity of arbitration. This particular arbitration agreement is invalid because it's unconscionable. State A cannot say that in refusing to enforce the arbitration agreement. Here, State B can actually say that, oh, unconscionability is one of the grounds of invalidity under State A's laws, therefore I'm going to strike it down. Although the courts of State A have approved it. It's an interesting maneuver, right? I don't think they actually contemplated this kind of outcome. As I said last time, when Pitt Sanders, the drafter, one of the drafters of the New York Convention, was in New York negotiating this and going through the General Assembly for approval, he drafted Article 2.3 right there in New York. They had been working on this thing for ages. The New York Convention was a big deal, and it turned out to be one of the most, useful instruments in international law. They inserted that provision, which turned out to be one of the most controversial provisions, at the very last minute. So they may not have been thinking all of these things that we are thinking. The reason why we're thinking about these issues is because of these, cases that later, about this, about that, about this, about that. If people learn how to write laws precisely in anticipation of every mix of circumstances that could occur, there would be no need for courts, right? That's why the courts are always open. There's always a new controversy, a new set of facts, a new application of law. So we have 4 more cases to go. Do you want to, let's take a 10-minute break and come back and finish those. Okay.
对，所以这个时候跟警有一个
是法院。
对，他是法院。所以这个时候跟警有一个第2条、第3条。
可以用那个他本地的法律来判断的。
我只能是把那个看把那个无违的情况限制在中间3个嘛，对，然后第一是事后审判的那个，他就是根据国外，他就是说你可以用那个。